Hi, are we ready to start?
Yes.
Nice. Dheeraj, are you here?
Yeah, I'm there. Apparently, it says that host has stopped the video, so I can't start my video.
Could you check now, Dheeraj?
Yeah, there.
Great.
Yeah.
Hi, everyone. My name is Snigdha, and I'm part of the TIE Bangalore team. Thank you for joining us today. This is the final part of the series Recasting the Business Paradigm by Bloom Ventures and TIE Bangalore. In this series, we've tried to cover all aspects of the HR, legal, and finance functions for startups during COVID 19. Today's session is on surviving the legal battle, where we'll be covering new government policies, commercial contract impacts, implications on fundraising, and service sheets. We have with us today Ashish Paparia, partner at Bloom Ventures, and Dheeraj Khanna, partner M&A and Investment at Constellation Blue. Moderating this session is Mithul Mehta, partner at Constellation Blue. So without further ado, Mithul, over to you.
Thanks. Thank you, Snigdha. Hi, good afternoon, of the five-part series that we've been conducting. I hope everyone has benefited from the previous four sessions. Thank you, Ty, for the opportunity of allowing us to share our thoughts. It has been a pleasure to be a part of this. So today's session, we've covered, like Snigdha mentioned, we've covered HR, we've covered finance, we've covered acqui hiring. The one thing that we also wanted to additionally cover as part of this series was legal. So broadly, we've divided this session into two parts. The first will be legal around routine, business operations, contracts in general, and the second, we have the benefit of having Ashish from Bloom here, so we can touch upon legal around the investments. Very quick, I think Snigdha has introduced, but I'm sure everyone knows Ashish Paparia, who is part of Bloom Ventures. He's a partner there. They're a very well-known early stage fund. And Dheeraj heads legal at Constellation. Constellation is an early stage advisory firm, that focuses on finance, legal compliance, and works with various venture capital funds and startups. And I'm a partner along with Dheeraj as well over there. Getting on to the topic for today. So we've been about 3 weeks down now since the lockdown was affected. We've just got to know today, not that it's a surprise, but we have another 2.5 weeks or so to go. There were various, knee-jerk reactions that I'm sure a lot of us would have taken when this lockdown was first affected. Sometimes taking decisions in a rush is not the best of things. So now that we've had, 3 weeks to think over various possibilities, opportunities, I think it's a good time to apply ourselves specifically on legal aspects, and then take all our decisions. So today, I think just to start off with, one key concept or other word that we've been hearing a lot in the last 3 weeks is force majeure. So it's basically anything, any activity not being possible due to a certain natural circumstances, what it typically means. But we've not really, when entering contracts or whenever discussing, these are either not there at all, or they just passed as standard, standard definitions and let go. But today we're all looking at that. So I think, Dheeraj, it'll be helpful if you could just touch upon how this particular provision has an impact on contracts, and what companies can do with this.
Sure. Thanks, Mithil. A warm welcome to all our participants. Like you rightly said, Mithil, these are generally the boilerplate clauses which at times are not given the due importance while negotiating and drafting the contract with what it should be. Probably this is going to change now, the current situation, unfortunately though. So like I said, look, force majeure are generally, if they denote the unforeseeable circumstances that prevent a contracting party to fulfill its obligations under a contract. Few of the major, just to touch upon on how the courts generally look at the applicability or enforcing of force majeure. Few of the points that are considered is whether the event qualifies as a force majeure under the contract, as in is there a direct link of causation between the event and the impossibility of the performance. Second, the is the performance then is truly impossible Then the last point being whether the performance is forcible and was whether the parties took any actions to mitigate that unforeseen event. Generally, this is how generally force majeure are considered upon. A few pointers on how force majeure is getting enforced in what we've seen and advised our clients is specifically when a party is looking to claim a force majeure, they have to show that they have taken some efforts to avoid or mitigate that event. The party would have to give a notice of force majeure to the other party, and the burden of proof will be on the party asserting force majeure defense. Right? So this is where generally we have seen on force majeure. As such, under Indian law, Indian Contract Act, force majeure as a definition is not covered, but this is a principle under the common law that has been imported.
Sure. So Dheeraj, we've had a lot of companies or founders come to us and tell us that we don't have this force majeure clause at all in our contracts, and I have guided a lot of them to you, in that case. So, what is the advice around there? If this contract is not there at all, how can companies, move on that? I mean, what can they do? What options do they have? What alternates are possible from a law perspective?
Sure. So I think the first and foremost is to examine and look at the nature of a contract. So a lease deed versus a commercial contract would be very different. The basic, the remedy or the possibility that the parties can look for if the force majeure clause is not mentioned in the contract is under the Indian Contract Act, specifically Section 56, which talks about frustration of a contract. But the key factor in frustration of a contract that needs to be looked or that needs to be kept in mind is frustration of a contract does not allow any temporary remedy to the parties. It will mean the parties are looking to negotiate to terminate the contract. Generally, I think in most of the cases where we have seen or where we have advised, the ask of the parties is to ensure there is some timely relief from the performance of the obligations, which Section 56 route will not provide. That talks about frustration. It says, if I have to quote, it says basically an act which after the contract is made becomes impossible by reason of some event which party could not prevent or will be a void contract in that case. So yeah, I mean, Section 656 needs to be looked upon. But just like I mentioned, in the case of a lease deed, since there is a transfer of interest and the lease is governed under the Transfer of Property Act, there's a provision in the Transfer of Property Act, Section 108, specifically subclause E, that deals with the lease being held void. But in that case as well, like I said, it will not be a temporary relief. It will be ensuring that the lease is void by the lessee.
But so since you've touched upon the rent aspect and the lease aspect, I think what we've seen as very common for at least early stage companies is that after salary costs, the second highest cost is generally rent. And we have had numerous calls in the last 3 weeks on companies asking us that, what can we do? Because offices have not been functional, rent costs are large, especially in cities like Bombay, Delhi, Bangalore. So while our advice has generally been try and take the moral route first, where we try and speak to the landlords and get some extension, get some waiver. That's probably the first route that everyone is taking. After that is where the legal route comes. So the way I understand what Dheeraj is saying is that yes, if you have a force majeure clause, you have an advantage probably. If you don't, the Frustration of Contracts Act or the Frustration of Contract, principle may be a little tough to implement, but there is a way in which that can be implemented as well, I think. Right. So, anything else on specifically on properties or rents that you would want to touch upon, Dheeraj? Anything? I mean, one question that we've also had is that there are standard clauses in rent agreements agreements that say that if you delay our rent, there will be an interest, and that can be settled against a deposit. So has there been any way out of that or thoughts around that?
Yeah, so I think just to break up on force majeure, like you mentioned, having force majeure is an advantageous. Just a word of caution there. By just having a force majeure clause will not suffice unless and until you prove that there is impact on the business, and hence you are looking for excuse of the performance on the obligations. And then obviously we can dwell more into whether the force majeure clause, how it is drafted, does that cover this current pandemic situation that we have, or the COVID-19 situation? Again, that's a case-to-case basis. On specifically other clauses, on the rent side, I think there's another question that I could see on the window was leave-in license. In like I said, lease deeds are generally which are governed under Transfer of Property Act. Leave-in license are just license or that has been provided to the parties, and it's not to be covered under the Transfer of Property Act. That will be governed under the Contract Act. On your specific question whether the rent can be adjusted by the lessor and from the security deposit, and if there is non-payment of the rent, then whether rent or license fee, whether that can be triggered, can trigger any other provisions. Look, it depends on how the contract is drafted. Generally, courts have, if at all this has to be discussed in the court of law, the court generally has seen, or unless there is the contract is that much watertight, in favor of the lessee or the tenant. However, it will be very sweeping statement, and would like to avoid saying that the lessors and the tenants listening in or participating are free to not pay their rental obligations or fulfill their rental obligations, which is not the case, because there are various provisions in the contract, in the lease agreement, that the lessor can take recourse to. Even if a party is able to sustain or determine that the premises they are not being able to use as under the Transfer of Property Act or under frustration, the lessor can obviously, because all these commercial areas will have their furniture and fittings in the place, right, or servers in the premises. So the lessor can obviously take a view that those premises are being in use, if not just physical presence of the employees. So it's very difficult to wriggle out from these obligations. The best course, like you suggested, speak with the lessor, speak with your landlords, and figure out the easiest possible option. Few of them where we've seen waivers, few of them we have seen deferred, few of them we have seen some voluntary. It's not a voluntary deduction so as such, but a deduction in the rental fees.
Got it. So I think probably opportune to bring Ashish in here. So we have had, I'm sure they have a large portfolio company set, and there would be some companies impacted on both sides, where others are terminating contracts with these portfolio companies, or portfolio companies trying to see if we can put those on a cash burn and try and extend runway and see if we can cut off a few things. So Ashish, is there any particular challenge that you've seen founders face, or questions that come up to you on this, and how is the industry at large trying to address these?
So Mitul, what I strongly have observed over the last 3 weeks is that a lot of these issues, if they are not well articulated in the documents, and for most of the cases it is not. We are seeing that the only process is a conversation and a negotiation. So whether it is rentals, whether it is even employment contracts, customer contracts, uh, please do understand that startups, when they are dealing with large enterprises or bigger enterprises which have a slightly better scale, this is going to be a very uphill task when you're going to get into battles when they are simply saying that we don't want to continue any further. Even if my portfolio company is on the right side of the law and we're convinced that they could have been treated much better, I strongly feel that litigation is not the right way, for the simple reason, Mitul, that Uh, we have limited runway, we have our priority, we need to get our act together to survive another year. We don't know how much the situation is going to last. Somewhere we do feel that this is going to be a situation which is there for short term. We are not likely to come out immediately. So then we are picking our battles across the portfolio, across whoever we are talking to. My advice has been that pick your battles. Don't unnecessarily get into legality and don't pull out the documents and try and point out responsibilities and liabilities. Your best way to go out through these scenarios is discussions and negotiations. And sorry for a long answer to a very short question, Mithun. But I also feel that any person who is sitting on the opposite side, if you want to try and get a sneak peek into his mind, start thinking of that person as a employee. And when everybody has been told to cut costs or stop cash flows, there is a panic reaction which we are going to have some suffering. So yeah, I know it's not the best of situations. I know it's not a very objective yes no answer, but like most things in life, even this is a bit of a gray and extreme legal position by virtue of the way the startups' balance sheets or cash flows are. It's hard to go down that path.
A fair point. So I think uh, any cash burning startup will look to optimize on runway definitely at this point in time, and it will look to cut off all the excess flab that they will have. I think what we all need to be cognizant of is that uh, there are chances that we will see a lot of litigation happening. Like Ashish mentioned that there are larger enterprises which have contracts with a lot of startups, and simply terminating these could be a large a lease that you've taken, or any contract for that matter, where we're kind of terminating it can lead to a scenario where down the line it leads to litigation. And if your contract is not read well or drafted well at this point in time when we're actually going for such terminations, it could be a short-term benefit but a long-term pain for sure. On that lines, Dheeraj, the one thing that I think it would be good to highlight is people who are executing contracts now. This could be any vendor arrangement, it could be a rent agreement, it could be a service agreement. Are there any specific clauses that one should be cautious of at this point in time that you would have advised?
Yeah, so specifically, when we've already discussed on force majeure, so it's clearly really important for at least the contracts which are being negotiated right now, that the parties get their legal act together, have their lawyers or legal representations on these contracts. Few of them, I agree, are very templatized in market, and you can just download from various online platforms. But yeah, I mean, if parties can have that legal representation, it helps, especially in these cases. So yeah, one being force majeure, where current situations should be covered, specifically in terms of if wordings in terms like any epidemic or pandemic is covered, that will help in at least clear one doubt whether the force majeure is good enough to if the clause is good enough to have that remedy available in under the contract. So that is one. Then material adverse change, both in the vendor contracts and in the investment agreements we've seen, is a critical clause where the parties needs to pay a bit more, have more focus on. Generally, specifically on the investment agreement sides, material adverse change or material adverse effect clauses, however they're worded, are typical walkaway rights, right? And if there are any, and the general clauses that you would see in a typical agreement would talk about any financial impact on the company. I don't think there would be very few companies, probably in a very different sector, somewhere like Zoom or some where people are using and might not get affected, but most of all the companies would be having some financial impact on because of this current situation, right? So having due carve outs there, putting appropriate representation and warranties in the agreements, be it commercial contract or any service agreement or investment agreement, is something the parties should look for focus on.
So I see a few questions on the chat. I think we'll take up the questions all one by one. Just in probably in a few minutes. Since Dheeraj has mentioned the investment documents, typically investment transactions take anywhere between 4 to 6 weeks, or at times even 8 weeks to close. So Ashish, how has the venture scene been? Because it is very likely that there would be term sheets that were executed pre-COVID, and now we're in COVID, and all of a sudden there is some panic. So we have seen a few investments not go through or getting delayed. Is that the case at large? Are investors looking to buy out some time, or are you seeing things moving but a little slower? You're on mute, I think.
I don't think we should. Sorry, yeah. I don't think, Mitul, we should dismiss the scenario as buying a little bit of time kind of a scenario. I said this yesterday also, and I have been vocal about this. The scenario is way, way more complex than what people initially thought this to be. Most people have turned around and to realize the fact that we are in this for a bit of a medium term.
Right.
It is not virus alone. On a separate day, at a better, more contextual point, I'm happy to take you through why I believe so. But that said, to your particular question, yes, we are seeing challenges. There are investors who are, whether on their own or by virtue of pressure from their ICs, are coming back and saying, we might need to renegotiate on the valuation or on the terms. We had some term sheets and we are going through whatever we have promised. We will go through, but then not necessarily that is being taken as an approach across the board for various reasons. Some investors who invest at the growth stage are investing and they keep public benchmarks, and the public market benchmarks have corrected between 25 and 40%. So they say that, yeah, we should discount it because valuation is a perception at best, and the reality is that the current set of valuation is much lower. So in a scenario like that, it's hard for you to really go back. Like I said earlier also, we will see more of these coming up over the next few months. Wherever there are cases which are being discussed, they will go back and people will go into a bit of a shell and revisit whether they want to invest, and if they want to invest, how do they want to proceed. And if they are proceeding, then they will have much stricter constructs laid out. This is my fear. I'm seeing some of it play out even at an early stage where we are dealing with some of those scenarios. As time progresses and if the situation doesn't change quickly enough, I feel that it will further accentuate across the ecosystem. But I think for companies that have term sheet on the table, like I said yesterday as well, you take the money on and move on. I think the reality is that situation has corrected itself. We can argue that whether it's justified for the investor to ask for a cut or no. There are both sides of the argument. I might say whatever I feel like, but the harsh truth is that, yeah, the money is available only at the revised terms. So my advice to people is that if you can survive for the next 21 months without that infusion, feel free to say no. That's perfectly fine. No moral obligations. But if you don't have a meaningful runway of at least another 4 quarters or so, you might as well take the money and run with it.
Sure. And I think you made a very interesting point yesterday that I would like to repeat today, is that any startup who goes through the journey from starting to becoming a growth company and an enterprise, looking at a 10 to 12-year journey, it is very likely that there will be one slowdown that you will see.
Absolutely.
And I'm sure that all of us are in that phase currently. Hopefully, we should not be there again. But this is the time when a lot of things get course corrected. As a business, as a person, and things become better. Is my hope after all of this. So moving on from that, again around investments again, we are seeing that new investments are slowing down for sure. Does this mean that there could be a scenario where investors will have to do, or companies rather would have to do internal rounds? Is this something that you are evaluating as investors, or have you seen companies evaluating that?
Yeah, so it will be a top-down effect. So at the highest level, you will see that large investors are going to avoid making new investments very quickly. They will allocate capital to their existing portfolio. Venture is a value chain where you typically will expect that after 18, 24, or 30 months, depending on how frugally or how much of a cash burn the company needs, you will need to source a follow-on round. And that is typically by a new investor, and the existing investors will participate. That's broadly how the value chain works. I do see that that value chain will break temporarily, and I'm very convinced it is a temporary shock. Will definitely be out of it. I'm very convinced about it. So when larger investors at the top are going to focus on taking care of their companies at the top level, somebody who has put in two, three, $400 million in a single company might want to just lend another $100 million or invest another 50 million by a bridge. That investor will surely not take a new position, and that situation will go on. So a Series C investor won't do for a B round. A B investor will be forced to take care of this company. I do feel that internal rounds will be the flavor for the next few months, like it happened 2, 3 years ago as well. The venture scenario cycles are much faster, while the economic challenge that we are going to face due to COVID is still yet to play out. But the venture funding scenario, once in every 3 years, you do see a phase where there is a 2, 3 quarter lull of external investments happening at large scale and momentum, and people are more inward looking. I think we'll witness the same for the next 2 to 3 quarters.
Understood. So just one thing that has been coming to my mind, as an advisory firm that provides legal services, both Ashish and Dheeraj can probably take this question one by one. It is very commonly said that agreements are meant to be signed and forgotten and kept in the drawers. We say this very often on calls, negotiation calls, but all of a sudden today, those are the exact agreements that we're all pulling out and reading through and through, right? So what from a generic perspective, how important is the legal aspect for two things? One, of course, your investment document, because lawyers are essentially the wall between a company getting money and not getting money. We face a lot of pushback when doing transactions, and there is some sort of resistance because transactions are not expedited. So one, that, and two, how important is it for your routine contracts to be vetted by legal? Because we are seeing that a lot of service agreements don't have some critical clauses at this point in time. Rent agreements with large deposits don't have some critical clauses. On a routine course, a founder would not like to spend money on legal, finance, etc., more than necessary. This generally falls under that more than necessary bucket. So any views on that? Anything you see changing going forward, specifically for the startup ecosystem? Probably Dheeraj can go first, and then
So I'll just list out few things which I think, especially the existing investment agreements, like you said, are kept and they're executed and kept aside, now needs to be actually looked upon because of certain clauses which the existing agreements would have, and then at least what we have seen is few waivers going out from the to the investors from the portfolio companies and the founders. Specifically, because there would be certain conditions subsequent that every company would have, where there would be certain timelines that will be put out. Generally, it's 30 days, 60 days, 90 days, whatever the case may be. So if any of those getting impacted either currently or in future, whether those timelines would need to be revisited, I think before that becoming a breach of an agreement, the founders and the companies would need to take specific waivers. And I'm sure investors, keeping in mind the general situation, would be more than willing to put that waiver on record. Specifically, again, information rights that again generally we don't see too much of negotiations upon. Now, information rights, how currently it are worded, that's another thing, whether the investors do that kind of a follow up and enforce them or not. But generally, if contract is asking, or if the agreement prevails that certain information right needs to be submitted within certain timelines, those timelines get pushed out because of the situation, right? So the waivers around that needs to be kept in mind. Then the one of the critical clauses that we generally see in the agreements are relating to the founder's performance and certain milestones. If there are specifically tranche-based investment or certain milestones to be achieved before certain money can come in, then the founders need to revisit those specifically. First, from the investment side. Second, if that are also linked with his or her performance. Before there could be a possibility of whether, I'm sure it's unlikeliest of scenarios that the investors are triggering, but there is a concept of significant non-performance that we have already we've seen in many such deals, that is linked with the definition of cause for the founder. So all these needs to be looked upon by the existing venture capital funded deal founders as well, to figure out if there are any waivers that are needed. Then best in time to make get that paperwork ready and have that in their on their side. That's it from my side.
So, Vipul, I know you wanted me to go after Keith, but Dheeraj has been fairly comprehensive. Yeah, I have been an advocate and I have said that statement many a times, that documents are for withdrawals. And that is something that largely is true. We are in the midst of a once in lifetime situation. I don't know any of our parents, unless somebody here has parents who have seen the Second World War, can recall situations where people were confined to their homes, and post which a sustained level of breakdown in supply chains, a complete lockdown on consumption, and breakage of the cash cycle. We've not seen that what we're seeing currently. And World War was in the 40s. So it's almost like 80 years, 70, 80 years since something of this magnitude happened in the world. So in a scenario like that, yeah, of course, you will bring down whatever stocks you can to safeguard your interests. But broadly, I still feel that this is once in lifetime situation, and I will continue to believe that. What I would do is strengthen documents and make sure that we take care of the concerns that we have across the table, and let commerce take its priority. I know today's question is more on legality, but we can talk about it.
Sure. So there are a lot of questions that have come. I think we should probably go on to those,
Yes.
given that we have about 25 minutes left. So I'll start with the Q&As that we've got. I think we've answered the question around what possibility there is around force majeure clause not being there, then what can be done. I think Dheeraj touched upon that, through the frustration of contract provision. So that's one. So that's one question.
Mittal, while you peruse the question, let me just take a couple of them which are fresh in my mind as I was going through the list. You can be ready with Dheeraj, and you can be ready with the next answer. That way we can help more answers. So Tarun has asked about arbitration process. Tarun, arbitration, depending on your jurisdiction, you have limited the options to Singapore or London. Well, I think if you have to force and choose between those two, I would say Singapore, purely for the fact that the proximity to India, and Singapore has emerged to be a better jurisdiction over a period of time. If Dheeraj has a different view, more than happy to learn the.
No, I think so. Ashish, Singapore is generally the preferred choice for the VCs in general, and for the parties. Only thing, I don't know if Tarun asked this question specifically on the investment agreement sides or not, but the arbitration and the seat of arbitration is also needs to be looked upon depending on the jurisdiction of the contract and the jurisdiction in which the governing law of the contract, right? So uh, while you're free to choose the procedural laws and the seat of arbitration outside India, but just bear in mind on the jurisdiction as well of the contract.
So Dheeraj, I think Tarun has one more question, around explaining a little more about the severability clauses which one may incorporate in contracts. Would you be able to touch upon that?
Yeah, so generally, look, these are, like I said, force majeure, severability. Generally, we see them in the boilerplate miscellaneous clauses. Severability basically entails if there is a specific portion of the contract which is not being, enforced because of any unforeseen situation, or as the case may be, on how the contract clause is worded. The rest of the contract remains intact, right? So if certain part of the business of certain part of the contract in relation to in relation to a specific business vertical is not being the parties there is a challenge in performing the obligations, then that does not sever the entire contract. The remaining portion of the contract still persists.
So there's one question from Saurabh Sharma. I think I'll just reframe this question so that it touches upon multiple things. So there is, I'm sure there are a lot of individuals who have received employment letters, resigned from their previous workplaces, and now because of these circumstances, there could be cases where companies are, pulling back offers. So both from a company perspective and an employee perspective, what are the potential solutions there, or is there any solution at all, in fact, in such scenarios? And what all do companies have to take care of when they're actually, probably pulling off offers that they've already made?
So I'll just touch upon. I mean, we kind of covered this topic in our previous session, but just to cover on this specific aspect, at least for companies who have made those offers, from their perspective, they need to revise. They need to revisit their agreements that they have executed with those prospective employees, and on the case-to-case basis, the call can be taken from the employees' standpoint, where they have put down their papers, where they've resigned from the, generally from their existing organization. I think the best course is the best course of action for employees is to go back and speak to their, existing companies. Yes, there could be some heartburn when the employee leaves, and depending on how good that situation is, the employees might be in that position to do that. Because just on another aspect on the companies, while I was just speaking for the prospective employees, the companies need to keep in mind that the offer letter, the date of joining that has been mentioned in the offer letter, that is the commencement of the relationship between the employer and the employee. And if prior to that, if there is any wiggle room in the agreement that has been executed with the prospective employees, the companies can take a call upon. But again, I think in all of these scenarios, I'm sure Ashish can emphasize more. Communication is the key, either from the employee side or from the prospective company side.
There's no disagreements. I think it's a very unfortunate situation that one is out from the previous role, and the existing organization stopped the offer. I think it's extremely unfortunate. We have seen precedences where enough number of companies have stopped offers. There were a couple of instances a few years ago where a couple of large, deeply funded startups had stopped offers at campuses. Of course, given they were campuses, there was a fair bit of backlash as well. But in the current scenario, I don't think there is much that will be possible.
Sure. So just addressing a couple of questions, around what options one has. So this might address or answer multiple questions. One, around lock-ins for rent specifically. Two, around, yes, litigation is the last resort. What steps before that? So I'll touch upon a few of these things, and Dheeraj, please feel free to add. So we have seen a lot of these scenarios coming into play. One must understand that as a first step, we definitely have always recommended that please speak to them first. And so when I'm talking about them, I'm saying the other party. And everyone knows that there is a slowdown. Everyone is hurt in some way or the other. So first try and use that route and see whatever best we can. After that is where litigation comes into picture. Litigation, of course, is not as easy because, like, I'll give you an example of one case we are currently dealing with, right? Large office, 1 crore plus of deposit. The tenant is asking for a waiver. The landlord has a certain loan that he has to repay. So it's a very tough scenario where you can't simply ask for a deferment or a waiver entirely, because there are obligations that a landlord has as well. So in these scenarios, we have always recommended that probably try speaking out instead of going the legal route. The legal route is a long drawn one. It will take some time. There will be some heartburn. There is money involved when you're talking about 1 crore plus of deposit. So of course, that option is always there, but it is always the second best option. Dheeraj, in case you want to add anything on that.
No, I think you covered it right. Legal. I think the both the parties in a rental agreement or in any agreement for that matter needs to look at that solution-based approach. I'm sure they'll appreciate that instead of getting into that prolonged litigation in future, which is not probably, I'm sure, beneficial from either party's standpoint. So yeah, I think communication is the key. Only thing for all the the lessors, lessee, and the licensees that we have, um, I think yes, communication is the key. But if you are going ahead and looking at any other legal possibilities, then important point that needs to be noted is how the notice clause in your contracts is worded. Generally, you will have again a boilerplate clause saying notice, and depending on the modes of the notice that you can service, a notice to a counterparty needs to be then adhered to. You might have a situation where you might intimate through WhatsApp, but that's not a communication that has been enlisted as a legal communication or as under the contract. So that might not work. So revisit your clause, your agreement, and figure out the mode of notice that has been mentioned, and that needs to be then implemented.
So, Mitul, before we go into the next couple of questions, I just wanted a minute, if you don't mind.
Sure.
So, there were at least 3 or 4 observations about how bad the situation is. While it is strictly not a legal point, since it has come up, I have a view. I just would like to express it for whatever it's worth. How bad does it get from here on? Does it get to the decade of the Great Divide and the Great Depression of the 30s? Well, to be honest, uh, the people who are forecasting some of these things, yes, I did hear one such talk and read one such article as well. And these are people who have seen great cycles and see the view from a very different height. So while I don't want to get into challenging, but I strongly feel that no, that's not likely to happen. And I have few points to just put out. Uh, we have managed. Let's look at it from a global perspective and then a little bit from an India perspective as well. Globally, yeah, we have the most prolific consumption-centric nations are in a bit of a mess. That includes America, a little bit of Europe adds to the consumption globally. And US consumption definitely means a lot to the world and economic cycles in a large part of the country. That said, there are going to be fair bit of internal factors. So far as India is concerned, we have managed to hold up before 3 weeks before we got into the lockdown. We have at about from 500 odd cases, we had about 6 or 7,000 odd cases of the virus infection. It is hurting the economy badly. Lockdown never is going to benefit. But I do feel that a fair bit of deceleration this year and next year onwards, things will start coming back to track. Consumption will come back to track faster as soon as the supply chain cycles start repairing, as soon as cash flows start moving. There would be measures by the government as well to make liquidity a little easier on the system. Interest rates will soften for sure, and they will soften further, is my belief. And once that starts happening, credit availability across the banking channels, as well as the unorganized sector, will start bouncing back. All that we need thereafter is a regular monsoon. Unfortunately, I have to say that is at the vagary of nature. So once we have some of these measures kick in and a regular monsoon, we are not more than a year away from normalcy to start kicking in. Some sectors will take much longer. Sectors that are dependent on direct foreign consumption will take much longer. But the local consumption factor patterns will start seeing semblance of normalcy as early as early next year. Go ahead, Mithun. Sorry, thanks.
No, definitely. I think that's absolutely true. In fact, I personally I believe that as a country we've done fairly well. Yes, could have done better, but I think we've done fairly well to contain whatever we can so far. And probably we have about 19 more days to see where we get to, and hopefully things open up in May. That's I think what everyone's hoping for. The one Dheeraj, one question, before taking any of the questions, we had one point noted around stamping. So that is one challenge that we're facing with each company today across the entire country, because stamping, one, is a state law. Two, a lot of it is a mixture of online and offline. It's not like you can simply pay and generate certificates online. So what I'm sure there will be a lot of investment contracts being executed in this phase of lockdown. There will be commercial contracts. What would you advise as best practice there, and what should companies do on that then?
So I think, yeah, I mean, you're right, Mithil, stamping currently for the agreements and for the deeds, share certificates and everything, it's a concern. What at least we have been following is specifically, speaking out to the other stakeholders and the investors involved. And I mean, there are very few, I think, vendors that we've been able to identify in some states, and in Karnataka we could identify still not, use them though, where we were able to do online, or they were able to provide online stamping facility. But I think what generally we have seen is, specifically for the investment agreements, parties going ahead with the execution as is, and once the situation eases down, the parties get that stamp papers for that current date and enter into an addendum sorts of, having the reference to the current investment agreement that they are signing, and ensuring that the commencement, or with the retrospective effect of the effectiveness or the commencement of those agreements, just to be on the safer side. So that's what we have been at least following and suggesting to all our clients.
Sure, and I think that probably works for service agreements and other contracts as well, then, right?
Yeah, I mean, that works for almost all the agreements. Like I said, very difficult to get physical stamp papers. Even if online you pay the stamp duty, the other aspect is you pay the online stamp duty and at least sit with that challan or whatever receipt is generated, and show that you made that stamp papers. And I'm sure parties and the government in question will definitely consider that. But yeah, other option is get the stamp papers as and when things are normal, and enter into an addendum sorts of.
Sure, and I think some sort of record keeping that this was not done this way because of this, because 3 years down the line, yes, while we'll all remember COVID-19, we may not remember the dates specifically. So it may make sense to just keep some record around why this was
Yeah,
done.
absolutely. And generally there will be specific resolutions that are required to be passed for authorizing someone to enter into those contracts, at least the investment agreement contracts, right? So it is good governance idea to put in a statement to that effect.
Sure. So we have one more question. I'll just probably take that. So it says, what is your view on enforcement of specific performance in a situation where force majeure or virus pandemic is not a direct cause for non-performance, but it affects the quality of performance and material terms, or subject matter of the contract cannot be modified at this point? So I think we've covered this in parts earlier.
Yeah, I mean, Mithil, I think the answer, unfortunately, is one size will not fit all. It has to be looked upon on case-to-case basis. While I think the question mentioned about specific performance, but it also says that the quality of performance might be impacted. Specific performance, depending on how the clause is worded and what is the nature of the contract, can definitely ask for, and the counterparty can ask for a specific performance, but I would assume the specific performance is also in relation to the certain quality benchmarks if that contract is in that order, right? So I think all of this needs to be looked upon. There is no general answers, unfortunately, that we can provide covering all these current situations.
Sure. Yeah, and I think it also a lot of contracts have different definitions. Definitions play a key role in quite a few of these things. We have had contracts where force majeure is there, but a pandemic is not covered under that. So it may be very specific from contract to contract, and may have to be looked at on a case to case kind of basis.
Yeah.
I think one more from Chandra Prakash says, should the agreed or renegotiated change in terms be covered in a separate addendum to the main contract? Yes, advisable. If at all you have kind of got to a mutual agreement that there will be a different set of terms or a different set of value, it is advisable to record it through a separate addendum. It always better than having it over email, for sure. I'll just scroll through if there are any other questions. Just 1 second.
So one question basically seeks to ask whether the current situation can be covered as an act of God under insurance. I don't think so. Dheeraj, your views?
No. So you're right. I mean, unless again, insurance on the policies, the wording, it's very different. There could be a possibility where the insurance claims can be covered. IRD specifically sent out a circular to all the stakeholders involved and mentioned that all the claims related to at least COVID-19 should be looked upon by the insurer in the policy providers, and
this is in the mediclaim, right?
Yeah. So again, needs to be looked upon. One of the related aspects that we have generally, or we have seen at least in few of the deals that are currently live, is where investors are asking for business insurance specifically to cover for these kind of events. As a mark or as a protection measure, which is I think insurance policy providers. We've specifically seen few insurance policy providers giving out specific insurances for this kind of situations, and not just the general business ones as well.
Sure. So just one question that has popped up, I'll probably take that. What should lawyers have as an added checklist for future investments in due diligence and contracts? So, we've been conducting a lot of diligence for early stage investments, and typically most of our clients, specifically Bloom, has always followed this practice of doing extensive diligences. So we have been pretty extensive, specifically covering contracts, but yes, maybe there was not too much of focus on these boilerplate clauses, on specific contracts. So my suggestion would be that at least the key contracts that have direct impact on the business, direct impact on revenue expense, maybe dive 3 layers deeper instead of 2 to check for a few of these things. Of course, a pandemic is not something that will come every now and then, but yes, that plus all the basic checks and balances that we have should continue. We have seen, in such cases, at times, people choose to do the process in a shorter time. And that shorter time means you're kind of concising and doing a limited check instead of an extensive one. So recommendation is for at least all the important aspects, do an extensive check. Yes, time is of essence always, especially in the current circumstances. Things have to close fast. So be cognizant of that, and yet at the same time ensure protection for both parties, I think.
Yeah, and I think it'll just add on a few of the sectors which I'm sure lawyers would be looking upon. And this is, and then sectors, when I say sectors, it's the sectors of the diligence report or chapters, however we call it. One would be the insurance policies and the coverage, including the business interpretation of what happens. Like you said, the material contracts is of very much relevance. mostly from ability of the companies to walk away in such situations. Because bear in mind, I mean, investors, when they are doing diligences, they are basically also looking at the material contracts the companies entering into, right? So whether those companies then have that ability to walk away if any of these unforeseen situations are there, that needs to be looked upon. Generally, we have seen, if even if a few of the material contracts not being there, then either as a condition precedent or a subsequent, depending on how much that matters at that point of time. In that case, renegotiated or changing the terms of that material contract is asked by the investors. So that is, I think, important. Generally, on few other things that the parties should keep in mind is, when they are at least entering into investment agreement. I'm sure, like Mithul, you said, time is of the essence. All the, to the extent that is possible, all the CPs that can be pushed upon in the condition subsequence, that should be the idea or way to go about it. And the representation warranties and the disclosures that the company need to look into. Generally, we've seen, again, at times when we are representing investors, companies and the founders probably not giving that much importance to the disclosure schedule, and either not disclosing at all or disclosing very few disclosures. Right, so it is important to get into those disclosures, because that will serve them as a excuse from the indemnity obligations there.
Sure. So we have about 4 more minutes. We'll probably take one more
Maybe
last
we should.
question. Or yes, Ashish, you have any thoughts?
No, go ahead.
Yeah. So probably just one more question. I know there are a lot of questions we probably left unanswered, but
Quite
we'll
a few
take.
people who raised hands also.
Yes. So just quickly on so there's one question around what sort of I'll cover two answers probably. One, are we seeing increased litigation is one, and two, are we, what sort of settlements we are seeing on the rent side. So first, see, litigations not yet, but I'm sure they will go up if at all, the step one around, speaking to people doesn't work. Then I'm sure litigation may go up. We've not seen that affected yet, because we are still in the first 2-3 weeks where people are still talking and trying to resolve it. But if at all that doesn't work, then yes, we may see that go up. Rent side, we have seen different kinds. We've seen 2-month deferrals. We've seen haircut anywhere between 10%, 20%, 30% on rent. So different kinds. We've also seen scenarios where landlords are not agreeing to anything at all. So no one size fit all, like Dheeraj said, for that. We are seeing different kinds. It all depends on your negotiating power plus what position your landlord is in. It kind of all depends on that. I think yes, we're probably on time. Any parting thoughts either of you have, Dheeraj, Ashish, on these to share?
No,
Good.
the only thing that I wanted to say was that things will definitely get better.
Yes.
I don't echo any sentiment or concerns that this is going to be catastrophic and all that. Yeah, we are facing consequences which are severe. We are witnessing a situation of lifetime. But at the same time, I think for good reasons, I'm convinced, and I would like everybody also to believe it, that we are going to flow and come out of it. Companies that are going to emerge stronger are the ones who manage to last through this phase. Yes, there will be businesses that may not sustain, but entrepreneurship will be alive. So on that note, I'm okay. Thanks.
Thanks, Ashish. Thanks, Dheeraj. And yes, definitely. I mean, in fact, I was just chatting to Ashish earlier today, and life as work from home has been busier than work from office for all of us, thanks to all these video calls and phone calls. So, yes, I'm sure we'll get out of this strong. And thank you all. Thank you, Tai. Thank you, Ashish, Dheeraj, for being a part of this. I hope this has been insightful for all. We can all be reached on our respective LinkedIn profiles. Dheeraj has shared his email address as well. And thank you.
Thank you so much, everyone. This is Vijeta here from TAI Bangalore. Of course, I'm Signa's colleague as well, and Mithul, Dheeraj, Ashish, fantastic. You guys have been super duper supportive to us. Just to let you know that this series has created a lot of buzz in the terms of the content, the knowledge, and the very nice sharing that each one of you have done it. Just to let everyone know that The Bloom team has devoted 5 sessions and their best folks from Constitution Blue, from Passion Connect, from their teams to come in and share this knowledge. Really, really appreciate this, Mitul, Dheeraj, and Ashish. You guys have been fantastic. And what we would like to also express is that we want to do more of this because we understand in today's, I mean, and thank you for the positive note also, everyone. I think that's important, that irrespective of all the challenges that we are facing, things will get better. There are opportunities that should be taken up. I did see that note which Ashish replied back saying that sentiment, yes, we are looking at all our investments and it won't happen immediately. But the point remains is that as long as good people are there to support, I think we can do this. We can foster entrepreneurship. We can, this kind of mentoring and knowledge sessions are of great value. From the bottom of our hearts, we really want to thank you all. And thank you to the audience. We have had a very good response. You all have been very patient, a lot of questions. And Mitul, Dheeraj, and Ashish, I mean, I know you guys will be willing to stay in touch with a lot of these folks. Much appreciated. And also wishing each and every one of you all the best with everything that is happening around us. Thank you.
Thank you, Vijeta.
Thanks.
And hopefully, when all this gets over and we are all going to be safe and healthy, we shall also catch up physically as well.
Yes.
Not now we stay safe and healthy, but we should all catch up. Okay. Thank you. Thank you so much. Snigdha, over to you. That is, if you're around, otherwise, much appreciated, everyone. Take care.
Thanks. Bye.
Thank you.
Bye. Thanks a lot.